His Excellency, the Governor of Nairobi County, had lodged a case on Friday to stop this unlawful process of his purported impeachment. The motion purportedly lodged by Honorable Imatok did not meet the legal threshold that is set in Standing Order number 67 and Standing Order number 72 of the Nairobi City County Assembly Standing Orders. Now, that rendered the entire process illegal, null and void, and he couldn't in any way proceed with a process that was in violation of the law. Number one, this whole motion was not in compliance with what is demanded of such a motion. He did not swear an affidavit. He did not produce the alleged evidence. He did not have the signatures verified of these purported MCAs who are in support of the motion. Remember, the law says that you must have each of these signatures verified of the honorable MCAs who ostensibly support the motion. So, because this is lacking, the court is concerned about due process. How can the governor be expected to respond to allegations he has not seen? If you post a motion on the website of the assembly, but you do not post A, the affidavit of the mover, B, the verifying affidavit of the alleged 1/3 of the MCAs in support of this alleged motion, and C, you do not produce the evidence that he is supposed to look at, that you allege is in support of your motion, and that the governor is supposed to respond to. What you're doing is carrying on a kangaroo process, with respect. Nothing evil intended by saying that. So the court has agreed that that due process is an imperative, is an integral part of the process of the purported impeachment. And therefore the court has said the impeachment motion cannot proceed, and the county assembly must comply. The county assembly is accosted by a larger and a bigger problem, because you have an acting clerk who is seated in office in violation of the law. There is no vacancy in the office of the clerk of Nairobi City County Assembly. There is a substantive clerk in the name of Mr. Jacob Ngwele. And Mr. Ngwele has said he has never received this motion. He has never seen any evidence in support. He has never verified any signatures of the alleged MCAs whom they say were in support of this motion. And so when you look at the entire process, you have to question the political drive that is intended to achieve what is such a monumental aspect of governance in this country, pursuant to Article 181A or B or C of the Constitution. The removal of the governor is not your joke that you play in class as a class 5 pupil or a Form 1 student. This is supposed to be a serious issue, but the flippancy, the light-naturedness that this whole process is taking or had taken is shocking, is dismaying, and it's not something that we should be applauding as a nation. And so therefore, it is important that everybody understands that there was no motion in law for adjudication or debate. Let's not have these theatrics in support of something which we know does not exist in law.